There's a really bit of a... I think we've been stitched up with that Human Rights Act, okay, because there's something very contradictory about it in what they're doing about intervening with Parliament, and these acts, you know, like declaring incompatibility or compatibility in the way they're doing it, right? Let me just try to explain this, right? So I'm just going to do it like with sort of like a notepad sort of scribble jot thing, right? So when they make an act of law, right, just draw on like a little piece of paper we're writing on to represent a little bill or an act, right? Like with the Assisted Dying Act now, right? They're putting a bill through Parliament, right? But they've got to declare that it's compatibility with the Human Rights Act, right? ECHR. Those are those articles, right? You can't actually have the law, or you're not meant to be able to make the law unless it's compatible. That's a law that Parliament have got to follow. It's like a constitutional law of Europe, right? Like our constitutional rights in England, like the Bill of Rights and the Claim of Right Act, etc. It's meant to be constitutional law for Europe, right? But, like, you know, you might say, what about parliamentary privilege and that? Well, the Europeans have got the parliamentary privilege. So, I mean, our parliamentary privileges supersede that anyway. They're part of our rights of our country. And the Human Rights Act is made compatible with that because in that section 6, I mean, you can type this in Google, right? Is Parliament a public authority? And it will say, no, the Human Rights Act section 6 says it isn't, right? I just typed it in multiple times to check it, right? But I worked it out myself from reading it, but then I went to Google to confirm it and support it, right? It's meant to be the act. It's meant to be the act itself that's not compatible, okay? So it's meant to be the act itself. Like, a judge is meant to say, like, this act is not compatible, but the judge can't make and change the law. But he can say that he don't think it's compatible and send it back to Parliament. But then it's up to Parliament to change it or alter it or do something. But the judge can only send it back, and it's like a professional opinion and official. I don't know if he can make them change it, right? Now, we'll get on to this whole issue with Shabana Mahmood and the Terrorism Act and the prescribed groups in a minute, right? But let me just tell you this, right? There's the current assisted dying bill, right? The whole thing is not compatible because the whole object of the act, right? The actual objectives of the act is to introduce, it's nothing to do with any particular clause in the act, like, you know, well, I don't think line 1's compatible, or I don't think line 2's compatible, or I don't think, like, this provision's compatible, or the act can't do this in it, right? The whole act, the entire thing, its purpose is to enact and facilitate in law for killing through the civil process of law, right? Through civil proceedings. It's not an act of criminal law, right? It's an act in civil law. It's an act for civil law, you know, like copyright or whatever, right? Civil law, although copyright can be a crime, right? If there's like piracy, a lot of it, right? But we're talking about, like, you know, if someone knows like ownership and, you know, property rights or rights to land, right? It's civil law. Now, let's draw this Human Rights Act at the top here, which is like this constitutional European law. So put a little box at the top with lines on it as well, right? The act to the left underneath, the new assisted dying bill itself, not like a provision in it or a clause of it, the whole act, the whole category of law it's in, right, to what it achieve, what the purpose, you know, like the title of the act, its purpose, right? The purpose and title of the act, usually in an act of law, like in the Victorian ones, they have them short titles now, like the Parliamentary Papers Act, right? But there's like a long title, and it usually explains what it is, like an act to provide for giving summary protection from criminal and civil charges through the publication of parliamentary papers, which is right through making them available to the public, right, for whatever form or whatever means, which distribution, right? That's the purpose of the Act. So we're not talking about, like this line of legislation is not quite right, it doesn't quite fit in with other laws, or it's not compatible, or it's contradictory, right? Or it doesn't make sense, or this particular part of the Act, doesn't give you your rights. We're talking about the actual design, intention and purpose, right? So you must know what I mean. The title of the Act, what is the title is an Act for providing what, right? You can't do that. So the top law of John Smaller, the ECHR, the Convention of Human Rights, actually specifically in the articles has a provision for that, right? And that is that you're not allowed to have, governments can kill, right, or make law that kills, other than for criminal process. Criminal process, right? And Tony Blair repealed the last death penalty, so we haven't got any, right? But they're wanting to introduce it in civil law. According to that top law, you can't have it at all, right? So you can't have that assisted dying act at all, right? Now, but so who decides that? Well, the thing is, the government in Jersey, like, for example, and they're doing it now with our government, they've made a declaration. Someone's assessed it, like Attorney General or one of the ministers, or whatever, right? And he said, this is compatible with the top law, but it's not. It isn't, because the top law there tells you that you can't have this law underneath at all. It can't exist in law. And the declaration is a lie. It actually, the thing that tells them they can't do it, they sort of have to include that, but they've only got a very small, short paragraph about it. And then they fill in. They fill in, it's like with filler, like totally irrelevant filler, to try and make it look elaborate and complicated, and that, there's all these like serious things to consider, when actually they're trying to dress it over and cover it up for the thing that actually says they can't have the whole thing. And there's no deliberation or weighing up, or what you call reasoning or proportionality or anything to it. It's actually explicit, right? In black and white, yes, no, and it's actually no, you can't have it, right? So all that compatibility declaration is tosh, right, for the island of Jersey. Now, you can go into a court and a judge can say that it's not compatible, right? But the judge doesn't make and change the law. But if a judge says it's compatible, that's like official, and the government can have to take it seriously, right? As seriously, equally, I would have thought, as if whoever wrote the declaration said that it is compatible, and the judge says that it isn't, right? But the fact is that in order to do the declaration of compatibility, it's clear that they haven't told the truth about it, and they lied. And that's perjury of oath, misconduct in public office, like they haven't acted according to law. They can't be that stupid. Because the Article 2 in the top act here is absolutely clear to understand. And then they use this ridiculous Switzerland case. I was going to say Switzerland case, which doesn't actually justify them making the act at all, because that's about the person, not about the government, right? The Article 2 is about what the government can and can't do explicitly, whereas that Switzerland case is all about the person, right? What the person's rights are themselves. They need to change the top law, right, if they want to have this bottom law. So that's compatibility. Now, the court can hear it, ironically. Courts can't hear matters to do with our parliament in making and changing laws. They're not allowed to hear privileged material. They're not allowed to prosecute us when we're supposedly using privilege in the Bill of Rights. That because you're actually going through a process of parliament to make or change law yourself, right? Or to put a public bill or private bill through in the public business or private business. When you're petitioning government, it qualifies for parliamentary casework, legislative process. This is why in the top act, it says that acts by public authorities are not acts by the Parliament or under the Parliament of the House of Commons, the House of Lords. That's why we're not going to be prosecuted, right? And I think they're trying to break down that border and get rid of it. Now, so to have the top act, I hope you're following this and you're clear, right? Because this is important. The top act, right, is allowing judges to decide and hear cases on compatibility, but only with ACHR, right? Only ACHR compatibility. Not with compatibility with our fundamental rights, liberties and freedoms and English law, which when you're doing that as a process of Parliament, right? Now, if you're putting through acts of Parliament and things like that, which aren't really anything to do with the human rights, and listen, there's a thing within a thing here, right? You know, like a Russian doll, like there's a thing within a thing, right? Look, this is a bit of a thing, right? Acts of governmental departments and any other public authority, right, are you can they're an act of a public authority, right, and that can have a judicial review. But an act, we're not talking about an act of law here, an action which is performed by a minister or the Secretary of State or Parliament itself as a legislating body, like making these acts and so forth, is not an act of a public authority. It's an act of it's an action of the government and Parliament, which is why we're privileged in our political causes, right? Now, so I'm going to now bring in. There is a bit of a mind twister to this, but hopefully I'll clear that mind twister up. Here, right, I'm drawing another act of law with legislation on it, right, on the right hand side. Now, let's say that is the Terrorism Act 2000. Let's say that's the Terrorism Act 2000, right? That's the act that Shabana Mahmood, as Home Secretary, prescribed a group as terrorists, right? And in order to do that, let's get another colour now. Maybe we'll get green. In order to do that, she writes into the law itself, it's not actually showing up right well, that colour. I don't think it's going to work. Right, I'll just do it like, I've got lots of scribbles on there now, right? You can see the thicker scribbles, right, at the bottom of that act on the right-hand side. So those thicker scribbles that I put on there, right, that's like at the bottom of the act, that is making or changing the act, making amendments to it, right, which is adding, like, to a prescribed group in law, right, you know, like this Palestine Action Group, right? So it becomes legislation. When she does it, it becomes the law. It's not like an order from a council in local government. It's not like the police issuing a dispersal order. It's not like... It's not an act of a public authority, because a public authority is not meant to be able to make legislation, right? They can't make legislation. It's not an action of a public authority. An action of a public authority, it's only an action of something that either the Parliament of England can do or a special power given to a minister or Secretary of State in their capacity, because they can make and change law as they're told to do. The Act says they can make it into law, right? Now, it's not an act or action of a public authority. Now, judicial reviews are only meant to be allowed to be done into public authorities, right? A judicial review is only meant to be allowed to be done into the public authorities. It's why the Ombudsman cannot act, even if your MP signs it, if you want to complain about an MP, right? Because the Ombudsman doesn't govern MPs, right? So you can't have a judicial review, and you're not meant to be able to have the Ombudsman acting, because it wasn't an act of a public authority, right? So when Shabana Mahmood, like, put the prescribed group in, right, things that subsequently happen from that can be actioned against, but not her for doing it, right? Not her for doing it. Now, but yet they had a High Court case against her, and they said that, you know, what she did was wrong, right, in a judicial review. Now, this is the thing where it gets a bit silly, because you're not meant to be able to have a judicial review or an action against them when it's not an act of a public authority at all, right? So the High Court weren't supposed to do it. And therefore, surely it's a contempt and breach of privilege, right? But then you say, well, if that's the case, if the High Court's not going to be able to prosecute us when we've got cases in Parliament, and when they're not supposed to be able to bring actions against the Secretary of State, right, because it's not an act of a public authority, and the Ombudsman couldn't have acted, so what about all this declaring incompatibility with a convention, right? So what if the Terrorism Act 2... But this is the thing. They weren't saying that the Terrorism Act 2000 on the right-hand side is incompatible with ECHR convention, right? Because if they say that the Terrorism Act 2000 is compatible with ECHR convention rights, then they send the whole act back to Parliament and say, we think that you should change or amend this, right? But the High Court didn't do that, right? What they did is... And that's what I wanted them to do with this, the left-hand side one, right, with the assisted dying bill, but before they've even made it, because they can even do it after they've made it, right? But this is getting into what ECHR is doing, is trying to say that courts and judges can decide about legislation when really it's for Parliament only. But they've said that, but that means that the Ombudsman could do it. That means that the Ombudsman you'd be able to put complaints into the Ombudsman against MPs for making and changing law, which they don't let you do, right? So why are they letting, Victoria Sharp and Jonathan Swift in the High Court and the other judge do it? If the Ombudsman if the Ombudsman says I can't have this, it's something that MPs did, right? So they've got something that they're lying to us, and they're playing with us around, and they're toying with us, right? Now, listen. That High Court case against Shabana Mahmood for the one on the right-hand side, the Terrorism Act 2000, putting a prescribed group in, right? Anything which happens subsequently after she's done it is under the public authorities, but her actually putting it into the law and saying she couldn't have done that, the High Court can't decide that. Now, if the High Court say, well, after she's added this prescribed group, right, then, that itself is not compatible with the convention, right? But the Act itself said that, in law, the Secretary of State can add groups to it and take them out. Now, if that itself is incompatibility with a convention, right, why didn't the High Court say, well, the Terrorism Act 2000 is not compatible with a convention, right, send the whole Act back, right? Which I wouldn't argue with that. But they're saying that, well, they're picking on one or two clauses is not compatible or whatever, the one that she's just made and put into the schedule, right? But her herself doing that isn't an act of a public authority, and it's not subject to a judicial review, because actually in the criminal and civil procedure rules, you're meant to have those incompatibility declarations as they arise in cases, in connection with other cases, and then they can send it to be looked at, etc., whatever, right? But it's meant to be for the Act. Now, if the argument of the I think it was a woman who actually brought that case for judicial review, she was wanting that prescribed group itself to be decided whether it was incompatible with a convention right or not. But if you can do that with one group, you can do all of them, and then the Secretary of State isn't being treated as making or changing law herself. There's the whole model that they've brought in now I think, is trying to take power away from the actual parliament and government. They're slowly trying to make it so courts can decide what Parliament can and can't do, and really taking power away from MPs and giving it to judges. But then the judges want it to take juries away, and then we're getting all this automatic crime and surveillance and things that automatically set fines and stuff out. We're not getting juries. And then it's almost like they're wanting the justices to take over from government, even though government are doing a lot of things that they're not going to be able to do anyway. Like on the left-hand side, they're not supposed to be able to make that assisted dying act because the Human Rights Act at the top, with that assisted dying, it's a specific thing, right? It's an actual, very clear, specific thing that you can't do what they're trying to do. It says that you cannot do that one thing, and there's no proportionality or reasoning or there's no deliberation around it. It's a very specific thing, right? It's like, in black and white, it's like, this is this, that is that, you can't do this or that. It's not like, if this, what's a reasonable, it's not like, what is a reasonable response, right? A reasonable response, right, to opening a door is debatable, right? Because it's how much force can you apply, and so much thing like that. Like a weighing scale, how much weight is on the weighing scale is proportionate, right? It tells you, and that means that the judge can, that it's not absolutely fixed and set. The judge can decide, whether, like 2 pounds of pressure or 3 pounds of pressure or 4 pounds of pressure was proportionate. I don't like that area of law. It's not my area of law, because that means that there is actually no exact thing. It's what I decide, right? So I can say, oh, you're pushing too hard, right? How hard can you push? It's measurable with a ruler, and it doesn't say that which measurement on the ruler it is. It's more like a faded rainbow across it, and as it gradually gets into it, and different people could call it at different points due to their opinion. This is where different judges would differ, right? That's not the law that I do. I don't do law like that, because that is judges love this area of law, and they're trying to do all law like that. They get carried away with themselves over the whole career, these magistrates and judges, and they gradually treat all law like that. Oh, I can decide, right? From what I think or whatever someone's told me, right? I get to decide absolutely everything, right? That's not how this assisted dying bill incompatible is with the Human Rights Act. It says you can't do it, right? In law, there's no proportionality. There's no what is a reasonable force or response, right? That is not applicable at all, right? Now, with this, the right-hand side at the bottom, the Terrorism Act, right? It says that it's created prescribed groups, right? You're allowed to, any group that the government wants to prescribe, they can do it. And it doesn't actually say in the Act, it doesn't scrutinise whether it was reasonable to do it or not or anything. It just says that they can prescribe a certain group, right? Now, that's a legislative power in law, like MPs voting on law or whatever, but it's given to one person in Parliament, right? And I'm quite sure that I'm correct on this, right? And it's not when they make that and put it in the schedule at the bottom, which I've scribbled over in black, right? They're making law. And it's not an act of a public authority. And you can't have a judicial review in that. And the Ombudsman can't act, or else, we'd all be complaining about MPs voting on laws, right, as well. But, so what's this thing where if something's, I'm going to draw on you now, incompatible with a convention right in there, they can get a judge to assess it and send it back. Isn't that what they were doing with Shabana Mahmood, right? But this is the thing, this is the conundrum. The justices seem to think that any line of legislation or any paragraph or whatever, including that schedule that she added into it, right, can be sent back to the government and say, oh, this isn't compatible, like, that particular prescribed group. But it's not an act of a public authority. Now, are they sending the whole law? Why aren't they doing it with, why did they declare compatibility with this assisted dying bill? There's definitely a slipstream here that they've done a thing, right, where courts aren't the High Court of Parliament, right? And the illegal prosecutions in the King's Bench for matters causes decidable only in Parliament, right? Except civil debt. You might say, well, MPs aren't protected from civil, right? Only the public authorities can be actioned against. I think some of the staff of Parliament can. But listen, if you could do this, right, what they've done, you'd be able to get the Ombudsman to do it for free, and they wouldn't say, oh, it's MPs, we can't act against MPs or ministers, right? And not when they're making and putting legislation into effect. We say, well, the whole Acts legislation, right? If you want to go to a court after they do this assisted dying and say it's not compatible, right? But that is a specific direct thing that the Human Rights Act says that you explicitly can't do in the article, right? The rest of the Human Rights Act is how law and rights are applied in practice, right? So the provisions, not the articles, the provisions of the Human Rights Act, like Section 6 itself, right? Or Section 7, right? Like when it says, if you are the victim of an unlawful act, this is making law now, you can rely on the right in any proceedings. That's actually what the criminal procedure rules are based on. The overriding objectives are based on that line. Because if you're ill and you can use if you are injured or something, and they don't let you have your rights or medical attention, surely that's a crime against you, right? So you've got to be able to rely on those rights if you're the victim of an unlawful act, right? Those type of provisions, if they say that they're not compatible. Now, this is the thing. The Human Rights Act itself, are they going to say that the Human Rights Act itself is not compatible with human rights? But that's the act that makes them, right? So can you imagine the ridiculousness, right, of a judge saying, this is a corker, this one, right? Going to a court and say, the Convention Rights, the Human Rights Act 1998, well, the Human Rights Act 1998 is not compatible with them. The Human Rights Act 1998, you go into a court and say, it's not compatible with its own convention rights, right? Or there's some sort of, you could say there's a contradiction, flaw or error in it, I suppose, right? But the ironic thing is that, you could actually say that the Human Rights Act itself is not compatible with our constitutional rights, but our constitutional rights supposedly aren't the convention rights. Now, in the criminal procedure rules, in overriding objectives, part 1 to D, it says that courts have to recognise all rights, including the convention rights of the Human Rights Act, ECHR. So it says all rights and those, but particularly those, but it's trying to, we've got other rights as well, like our constitutional rights, privilege of Parliament, and the ECHR have to be recognised and upheld, right? That's the criminal procedure rules. And also, if you are the victim of an unlawful act, right? Well, what are acts that are unlawful? Actions that are unlawful? Well, being prosecuted illegally, if you're doing things in Parliament, is an unlawful act against us, right? And also civil action, because, you're not allowed to be arrested by someone on messing a civil process, right? Illegal action. So, in theory, according to Section 7(1)(b), if you are the victim of an unlawful act, right, it can be relied upon in any proceedings. If they prosecute Shabana Mahmood for making legislation, a legislative making process into a schedule with a civil action when it's privileged by Parliament, she is the victim of an unlawful act, right? She's the victim of an unlawful act, and you can enforce parliamentary privilege, right? But what about the judge hearing it and sending it back, for scrutiny. Well, I've just discovered an incompatibility there. I've just discovered an incompatibility with the Human Rights Act 1998 itself. Because if you bring a civil action against the Minister or Secretary of State when it's the legislative process to make law into effective law, into the schedule, which is a legislative process, not an act of a public authority, like voting legislation through Parliament, right? According to the 1688 Bill of Rights, illegal prosecutions by the King's Bench from as cognisable decidable only in Parliament, right? That's breach of privilege, and you're the victim of an unlawful act, right? And they can't bring it. So judges raising ECHR violations itself is a breach of privilege. It's an illegal act. But they made it in the ECHR. So the Human Rights Act 1998 ECHR isn't compatible with existing law, surely. And this is the thing. They're wanting these judges to send things back when actually then it says that, well, it's not an act of a public authority and you can't have a judicial review, otherwise the Ombudsman could act and you wouldn't even have to, pay for judicial reviews. I don't know if that woman got it for free or not. I'm not sure. But anyway, so I said that it's a bad idea to repeal the Human Rights Act because some of those articles are good, like the right to privacy and life, but they're not upholding those. They're completely ignoring them. On the left-hand side, with a red line through it, the Assisted Dying Act, they've ignored on purpose the GITs. They are a set of GITs, right? They're not experienced in law. They're not legally experienced. And they vote stuff through that can't exist in law, and it breaks the own laws they've made, and they've not researched it or looked into it properly, and they're even trying to cover it up. I think they know, right? So they don't want to comply with the law that they've made, and they're lying and doing misconduct to try to get it through. The right to privacy is utterly violated, and no one's even brought any cases on it because they brought it in from America through the platforms, and they've got everyone to consent to agree covertly without realising what's going on. When all that's from Mark Zuckerberg's business, other partners collecting data on you, there's not an urgent pressing social need for it. It's all private profit and business needs. So they don't have any right to have it or force you into that policy, but no one's prosecuted them or brought a case against them in the court. And then you've got the Big Brother Watch stuff with the cameras and facial recognition and that, and then you've got all this spying on where you're driving to and where you're going to. 15-minute cities are taking privacy away. That's against the right to privacy. You can prove that as well. You can even do private bills in Parliament, I think, to stop them doing that in certain areas and stuff like that, or all kinds of stuff you could do to stop those 15-minute cities. They're not. No one's going into court and no lawyers are making representations for right to privacy properly. And the government are letting the Americans come in and the Chinese and take it all away. And they've already done it now. They know everything about it. All the people they wanted to know things about it is done now. And you'll never take that out of those people's brains unless you drill into it, like on 007 movie when Blofeld's got him in a chair and he's erasing his memory, drilling it out, right? They know what they want to know, right? They've looked at it, they've perved at us. They've been the voyeurs, the perverts, the snoops, the sneaks, and they know that in their minds now. They've perved us. We've been stalked. We've been stalked and trojaned. It's done, right? And that's all against ECHR. Total ignorance, just as much as this violation of assisted dying is. So they've not upheld those articles at all. Nowhere near what they're meant to be done. And now it turns out, really the whole thing is very contradictory and flimsy. I don't think ECHR is compatible with our constitutional law. I thought it was because they'd separated acts of public authorities from acts of parliament, and you're not meant to be able to have like a judicial review into parliament because that's a breach of privilege, right? But then the judge can send it back. But the judge the judge doesn't decide though. Well, they are deciding. Sorry, the judge doesn't make or change the act when he sends it back. Only parliament can do that. But he's he's sort of raising a concern about it, but they're still making a decision on it. He's still making a decision on the legislation, which courts have got to apply law, right? Not scrutinise it. So if they're going to be doing this, if they're going to be, saying that, Shabana Mahmood putting that, they can send the act back to Parliament, right? But they didn't send the act back to say that this act is not compatible. They tried to make out that the particular prescribed group that she put in there, she shouldn't have done it, right? But are they saying that, she shouldn't be, they want to pick it. They're wanting to make it so the court has got the decisive power that was given to the minister through the legislating of the act. The minister has got the power to decide of if a group should be prescribed and put into the force of law. A court can't do that, right? And that's not in the power of the court, right? The power of the court is when you apply law, right? And that is all the things that subsequently happen from legislation being in effect, right? Not the act of putting it into effect, which is what MPs do when they vote it through Parliament and put it through, right? So for the judge to send it back, and now, Suella Braverman thinks that the Human Rights Act should be repealed, that there's something wrong with it. I see what's wrong with it now. But that, they're doing it rather than just saying, right, they should just say the Terrorism Act 2000 is not compatible with convention rights because, but the problem is that when people were committing acts of terror, right, they're the prescribed groups and their actions can be acted against by the authorities, right? But the police, being incompetent and not really knowing what they're doing properly, were misidentifying persons holding signs and banners promoting causes to Parliament in order to get Parliament to act, which is really the proper way that you're supposed to go about to get Shabana Mahmood to unprescribe the group, right? By public business to Parliament, right? The public business to Parliament, public bills to Parliament. We are promoting for Shabana Mahmood to unprescribe the groups, right? And stop, acting with this legal stuff against Palestine, right? So we're holding banners and signs to promote that cause, which is the equivalent to Parliament, to the House of Commons, as what a barrister is doing in a court, if you wanted to represent the Palestine groups or pro-Palestine, to defend them in court, and if he wanted to put witness appeals about the case out in public or in the newspapers, the police wouldn't arrest the barristers, right, for doing that. So the promoting of public bills and business to Parliament has been misidentified as acts of terrorism, which it cannot possibly be because it's legal privilege, which is in the 2006 and 8 Terrorism Acts, but it doesn't mention it in the 2001. What the court should do is send if they want to say that, they can send, say that acts are compatible, send the Terrorism Act 2000 to Parliament and say that, you need to say that, legal privilege applies like it does in the 2006 and 8 ones for it to be compatible. Because can you prescribe the police? According to the Terrorism Act, doesn't mention legal privilege. So does that mean the police's legal privilege is not in there? So you can prescribe the police if they're turning on the country and they could be a prescribed group, right? Or if you're saying you can't possibly prescribe the police, then that means that legal privilege applies to it. This is the argument, right? But they misidentified. They shouldn't have been prosecuting all of those people. And that person shouldn't have ended up in court, and they shouldn't have had to appeal, and then the court shouldn't have had to say that, Shabana Mahmood shouldn't have put the prescribed group in. It was actually the police's fault. They're not interpreting and applying the 2000 Terrorism Act properly in public, right? And then that's led to all this. So it shouldn't have even been up for scrutiny of ECHR at all. It's the police who are wrong, and the police are at fault, and the policing minister, and the police commissioners, and the police chiefs, right, who aren't doing their job properly. They don't know the law properly, and they haven't applied it properly. They've misidentified people, right? And that's the problem with this whole thing. People don't understand the law, right? Particularly when it even comes to making the law, which they can't. If you can't understand that Article 2 of ECHR says that a government isn't allowed to have certain laws, and it can only have assisted dying, it can only have killing, which is assisted dying, in criminal process. You can only kill someone in a criminal process. If they can't understand that in that act, they shouldn't have stood for government. They aren't fit to be in public office, or they shouldn't be charged with the powers of making legislation in this country. They should be working in Costa Coffee, or they should be working at, Dunkin' Donuts or something, like that woman who was in the Michael Westwood petition debate, banging on about foreign interference. What her contribution amounted to was like, morning TV women's chat show level of a participation, or like sat in Costa Coffee with a donut type of intelligence. It wasn't fit for service in the House of Commons or government. To have these people in there is, why don't we just let 12-year-olds drive on the roads? Why not let 8-year-olds drive on the roads? You wouldn't do it, would you? You'd say that's dangerous. That's irresponsible. But with diversity and inclusion, we're getting people like this in Parliament. But then again, that Tony Vaughan, whatever he's called, I think he's called Tony Vaughan KC. I think he's on the petitions committee. He voted in favour of assisted dying. He's a barrister. He should understand that 2000 Act Article, the 1998 Act Article 2, right to life. He should know that and understand it. He should know that what Parliament are doing is illegal and wrong, and not trying to make an argument for it. But even though barristers try to win cases, they're not meant to lie about the law or disregard the law, even if they're desperately trying to prove a case for their client, and put an argument through what was a proportional response or not, what is legal and not legal. That act clearly is making assisted dying illegal, unlawful, and there isn't an argument around it, even if you bring in case studies, because the case study didn't change the law. If that Switzerland case had resulted in it being lawful, then why wouldn't they have said, well, now because as a result of that Switzerland case, you'll have to amend Article 2. But the result of that Switzerland case didn't result in all countries in the EU having to withdraw or change Article 2, did it? They just left it. So if it had had an impact on it, they would have had to change the law, right? They would have to change the law of the Human Rights Act, but they didn't. They haven't. They're trying to get laws through while it's still the same. So there's something wrong with these people. They're rushing things through and not thinking about them, or they're just trying to bluff and blag us all. And maybe Suella Braverman's right. Maybe it does need repealing or changing. But the way I see it is that there's a defect, because firstly, persons have been wrongly charged and prosecuted by the police and misidentified, and those persons should have been claiming parliamentary privilege or legal privilege, and then the case would have been dropped. Instead, those persons who got charged, instead of doing the proper claim under the English constitutional law, they started to say, oh, well, Shabana Mahmood shouldn't have done this or that, when it's actually they really, through using Parliament and pursuing public bills and promotion of a public bill causes to get Shabana Mahmood to act, and they're protected as much as Shabana Mahmood was. Instead, it's the protesters and the protesters' lawyers who haven't got a clue what they're doing. They don't know the English constitutional law. The police didn't, right? And instead, they brought this incompatible with EU thing against Shabana Mahmood when they, just like unlawfully, really just when they shouldn't have been prosecuted lawfully, when it shouldn't have ended up in that position. That challenge, the challenging for the ECHR challenge is meant to be for, like, you know, if you find old acts of law which are really kind of like, you know, not compatible with, you know, freedom of expression and things like that. But most of them are, like, you know, the Public Meeting Act is to promote the freedom of expression online and freedom of speech. That's actually the Public Meeting Act is a good act, but it's not even ever enforced. And the police never want to enforce it. They get it mixed up with the one for local councils. They don't think that we've got privileges. And Facebook has been breaking that law by creating all these policies, agreements, groups, which you don't have to say this or that in the group, or someone can control if you can speak or not. That's all against English law. That's totally against the Public Meeting Act, and no one's taking Mark Zuckerberg to court, and that's actually a crime. That's not like challenge it with a civil case against Facebook and YouTube. That's crime, and we're paying for the police, and we're paying for the police, and they're not doing really serious, important things against very, very big platforms and organisations, which are breaking English law severely with what they're doing, and even encouraging admins and moderators to do it, you know, which is what people are talking about now, that they're trying to, like, shape the whole culture and so forth. The whole thing is very unprofessional, and, you know, you might say my talk's not, you know, this is a summary. It's not meant to be anything more than a summary of the general issue, and, you know, we can go into specifics around exactly, you know, what judges can send it back and when and through what process and things like that. I'm talking generally. Those protesters shouldn't have been prosecuted, and their remedy exists in law for contempt of Parliament, right? And legal privilege, which have been ignored, and they ended up having to get the whole act what Shabana Mahmood's done, when really they shouldn't have been prosecuted in the first place anyway, right? The specific people were being prosecuted. The other people who were doing acts which probably did constitute terrorism, right? I mean, you know, it does the whole. It seems a bit of a con, because what they're saying is that it's a contradiction, isn't it? That the Ombudsman can't act against MPs or any legislative making process, which would include putting something into a schedule in an act, right, to make it law. The Ombudsman can't act. So how can you have judicial review on it, right? You know, or otherwise the Ombudsman could be, you know, bringing loads of incompatibility with human rights claims and everything that the government are doing, right? But they're not. They won't let you do it. The Ombudsman say, oh, we can't act, we can't do anything, right? Well, like, they're all compatible with convention rights. Everything that you know, we can't act when it's MPs. Well, you know, the MPs have acted incompatible with a convention right. When they voted, they're all guilty of a crime. Well, the Ombudsman won't act, so how can you have judicial review? Because that's a civil process, right? You know, they've made a little slipstream where, hey, look, we'll give the judges some power, right? But you know, Gordon Brown didn't want why did Gordon Brown make it so the justices, right, don't vote on law and aren't involved in the House of Lords process anymore, the law lords? Why did Gordon Brown do that? Gordon Brown's like, oh, well, the law lords, we don't want them to vote on legislation or anything like that, or have them, you know, on the lawmaking process. But then, like in 1998, they said, well, justices can say this is not compatible, and then say, I want Parliament to make changes to it. So what was the point in doing it? Right? What was the point in doing that? Why in 1998 would you say, oh, judges can send something back to Parliament, and then why would Gordon Brown say, well, we don't want judges deciding on legislation or voting on it? The law lords, because they're the main highest ones. It doesn't make sense, does it? It does not make. Why would you do that? Why would you remove the law lords from Parliament, right, in voting on legislation and having a say in it and involvement in it, when in 1998 you said that justices can say this is not compatible with convention right, yeah? But those convention rights don't always apply to all acts and all things, really. You know, and then, you know, like European Parliament have supposedly, you know, got the most enforceable privileges in the whole world. Supposedly, European Parliament. Apparently, don't know how you can have more than legal prosecutions by the King's Bench, right? For matters cognisable, decidable only in Parliament, right? And we said, oh well, you know, civil's not a prosecution, but this is the thing. You're not allowed to civil. It was meant to be like, you know, civil people arresting MPs and things like that, and for civil debt or things like that. It says that you can't use protections for owing money to other persons. You know, like when MPs were sorting their estates out and things like that, right? It's not meant to be for like the things that Parliament are doing in their business, or else the High Court of Parliament is not supreme. It's really concerning. So, you know, maybe Suella Braverman's right. You know, maybe she was right and maybe I'm wrong. But that particular case with Shabana Mahmood shouldn't have occurred. And that girl who brought the judicial review, you know, the whole thing's questionable because you could have, you're meant to, for like, look, right, for that, look, for Shabana Mahmood putting the thing into the schedule, right, the prescribed group into the schedule, you're meant to pursue it in the public business to Parliament to get her to remove that. And you're going to get loads of signatures to do it and get MPs to debate on it or put a complaint in by petition. It's going to be taken seriously to get the group prescribed, not go to the courts. And that's kind of what people were doing with the signs and so forth when they were getting arrested, right, to raise awareness. And that process isn't being used. People aren't even bringing private bills into Parliament. There's like one every session or two every session, right? You're not going to go to the courts. Parliament's High Court. And you might say, well, they're not letting them do the e-petition about it or no one's signing it. Well, you should be out collecting signatures and getting the, 100,000 signature debate and then more, I'm pretty sure that if they'd got 3 million signatures like Michael Westwood, did to try and dissolve Parliament for Shabana Mahmood to unprescribe the group, I think, 3 million signatures might have done it. And that was the proper judicial process to go through, right? I don't really think that incompatibility with convention right is meant to be done like how they did it with Shabana Mahmood, because those people shouldn't have been arrested in the first place, right? And they shouldn't have ended up in that situation. It's mainly for like an act of law, right? If there's an act of law, which is like it's meant to be for like this assisted dying bill, you just can't have it, right? It's totally against the convention rights. Not like they weren't saying that the Terrorism Act 2000 was against convention rights. They said that one of the groups that she put in them on the list was against it, right? Which, well, if you can have that, you might as well say that, well, you might as well argue every time she put every single group she puts in. But then the courts are deciding what group should be prescribed or not. So why make the law when it's the Secretary of State who has the power to prescribe the groups? Why didn't they have the act of law so the judges decide what groups are prescribed, right? That is absolutely and utterly ridiculous, right? And I know I've only done this crude drawing, but, something needs to be done about this because I actually believe that the Human Rights Act now, and I was against Suella Braverman on this, and I'm against Suella Braverman with all these ridiculous Reform UK advertisements that are illegal and all the, fan club groups when there's meant to be elections going on and all that. But on that point, I think she probably might be right now because, isn't it an unlawful... aren't you the victim of an unlawful act if someone breaches the privilege of Parliament against the Bill of Rights? So that's a judge sending legislation back is an unlawful act according to the Bill of Rights. So that makes the Human Rights Act itself incompatibility with a convention, right? So what you want to do is basically you want to have a judge in a court, right? Whether it's the High Court or whatever it's prescribed to have, right? Because I thought that you could do it in any court, but maybe they send it up to the High Court, right? I thought that even a magistrate or a Crown Court judge could send it back to Parliament or put a recommendation in at least. I don't know if it had to have a specific judicial review in the High Court. He said you can do it in the criminal procedure rules, right? And criminal cases don't always end up in the High Court. So apparently it could be found incompatibility, surely in a normal trial, right? According to the criminal procedure rules. But I think it does have to get sent through some process, right? But what you want to end up with is a judge saying, I'm going to send this legislation back to Parliament because it's incompatible. But in doing so, I am in contempt of Parliament because this is a matter cognisable, decidable only in Parliament. But that's the thing. I think I've also read now that you've got to have leave to do it or whatever. They have to have leave to do it. So it seems to me like, and maybe like I've only just brought this in now at the last minute, I did read something about it that they've got to have leave, and you might say, well, you're not very informed on it or educated. Well, I did read it, I approached it from the criminal procedure rules that it exists, that they can do that, right? Not from the High Court aspect of it. It did say something about leave, and then there was some process that you can use COP 10 and you can get an MP to step in and help or whatever, merge with the party. So like that was in one of the websites that I read. If you do need, if they have to get leave or they do need leave for it, right, to do it, then that's like, a court is allowed to mention a matter of Parliament, right, which is what you do. Well, what was supposed to happen in my case, they were supposed to have leave of court to even mention it or talk about it, which they, then they can even actually mention it in there and so forth, right? But even if they can mention it, they're not supposed to be making decisions or deliberating it. So even if you've got leave, right, to mention it and talk about it, which they're doing unlawfully with a lot of these Extinction Rebellion cases anyway, I mean, it's the decision that I don't think this is compatible, but it's legislation, right? That surely they shouldn't decide that, whether they've got leave or not, So there were a lot of questions around this.